Now, since everyone is here, I'd like to call the meeting of Board of Appeals to order at 5:31 p.m. Looks like the members present are Michael Polson, Cara Espera, Wendy Smith, and John Tutenhoff. Also present, we have Attorney Baer and Inspector Burris. The meeting has been properly noticed and posted according to law. And I will turn it over to Wendy Smith, who is the chair.
Hello, good evening. Welcome to this meeting of the Board of Appeals. Toya, do we have a quorum here?
We indeed do have quorum, yes.
And we don't have any extras or unnecessary members?
We
I'm trying
do
to look
not
over the.
seem to have any alternates, no.
Okay, great. Alrighty, well, good evening. Welcome to this meeting of the Shorewood Board of Appeals. For Toya, we do have an agenda for this meeting that was distributed as part of our agenda packet. Let's see, Toya, did you already take roll?
Yes.
Okay, I'm sorry.
I did, yes.
At the beginning of this meeting, I did not have my audio working, so if I missed something, I apologize. Okay, so let's start with item number 4 on our meeting agenda, which is consideration of the meeting minutes dated August 8th. Those are included in our packet starting on page 2. Do members of the board have any comment or objection to the meeting minutes as drafted?
No, I don't have any.
All right. Hearing no objection to these draft minutes, may I have a motion to approve the minutes as drafted?
So move.
A
Thank
second.
you. Thank you, Michael and John. All those in favor of approving the minutes say aye.
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 Aye. Any opposed? Hearing none. Those meeting minutes as drafted are approved. Right. Moving along to our 2 items for consideration this evening. Item number 6, a request for a variance, and item number 7, also a request for a variance relating to downspout disconnection. 2 separate issues, 2 separate considerations, but we do have our village attorney here, Nathan Baer, to help us understand the proper standards of review for this particular type of consideration. And perhaps we can turn it over to Nathan for some preliminary information about the board's responsibilities in reviewing these matters.
Thank you very much. Can everyone hear me okay?
I can hear you.
Yes.
Okay. So I want to work from the general to the specific. Often requests for variances come before this body that are discretionary regulations put in place by the local municipality. Big examples that come before this body all the time would be setback requirements, how close a particular building or structure can be to a lot line, whether or not a single family residence is required to have a garage, where you're going to put the HVAC equipment or the HVAC equipment, that kind of thing. So those are, again, discretionary standards that are set by the municipality. So it makes sense that the local municipality also has the opportunity to say, well, there's a specific condition on this particular property that we think that regulation would create a hardship, and we're going to grant you a variance. However, in this particular instance, this mandate comes from the MMSD, and they have mandated that Shorewood implement a program to disconnect in the combined sewer areas from the sewers. So in other words, the downspouts shouldn't run into the sewers. So this is different in the sense that MMSD has that power based upon a mandate from the state legislature, and that's statutory. And so the Public Service Commission is also involved in codifying these rules and regulations in administrative code provisions at the state level as well. So the village would run into a problem if it just said, well, we really don't like this program, we're just going to exempt everybody out by granting variances. That would put the village at liability with respect to MMSD and the PSC, and which is the Public Service Commission as well. So in my opinion, because this comes down from a mandate that's essentially granted power to MMSD and the PSC by the state and the state legislature, my opinion is that the Board of Appeals at the local level does not have the power or authority to usurp the program and say, well, yeah, but we're just not going to follow that, because again, that would place the municipality at liability. However, that doesn't mean that it is completely the end of the analysis. So I want to refer back, I'm just going to refer back to the ordinance, and the ordinance basically says, the applicable ordinance says that you cannot, in the combined service area, you cannot connect the downspouts to the sewer, the underground sewers, if the following conditions are present. And then it says the roof drain is external. B is sufficient space is available to locate the discharge point at least 5 feet away from the basement or foundation walls and property lines. C, previous surface is available at the discharge, or I'm sorry, I need stronger reading glasses. Pervious surface is available at the discharge point. And D, the discharge location is level or slopes away from the structure, but not so steep as the discharge would cause erosion. So in my opinion, that there is still the ability to appeal on the form, the Board of Appeals appellant form. The box is listed as essentially appeal to interpret to allow. And that's basically saying I disagree with the application of the ordinance itself. So I think that an individual who has been ordered to disconnect can make that argument that they can say, well, we think that the village improperly interpreted the code. And in my opinion, it's limited to those 4 things. So in this particular case, we have a staff memo, and the staff memo does address those 4 elements, and they've made a determination that those conditions are present, and the downspouts can be disconnected from the underground, the sewer. And so then that begs the question, what type of review would the Board of Appeals apply when they're determining, when they're answering the question, did the inspector interpret and apply the code correctly? Not a variance, but whether the code was interpreted and applied correctly. So, so really the question is whether they correctly applied and interpreted sections 225-6 and 415-18 of the Village Code. So basically the courts have said that when you're evaluating a municipal official's decision, there must simply be a rational, non-arbitrary basis for that decision. That's what constitutes substantial evidence to uphold it. So the Board of Appeals is to examine the record for any substantial evidence that supports the inspector's decision. And Wisconsin courts have held that substantial evidence test does not require even a preponderance of the evidence, but merely that reasonable minds could arrive at the same conclusion as the administrative body or the administrative official based upon the records before it. So based upon that, my suggestion to the Board of Appeals is first ask the applicant whether they are indeed seeking a variance. If the answer to that question is yes, then my opinion is the Board of Appeals does not have authority to usurp the mandate of MMSD. And if the applicant says that they're challenging the conditions that we read, A, B, C, and D, if they want to challenge that the conditions are present to require a disconnection, then we do the following. Conduct a hearing where the appellant and the inspector both testify, and then apply the substantial evidence test and make a decision as to whether those factors are present or not. So that would be my recommendation to the body. And I will stay for the meeting to assist with any procedural questions as they arise.
All right, thank you. I'll perhaps open this up to members of the board. Are there any questions for Attorney Bayer at this time about the standards of review or our pathway forward here?
Not on those issues.
All right, perhaps at the onset then, we have two separate applicants here in our agenda packet. So
Excuse me,
item
Wendy.
number, oh yes, go ahead.
Sorry, Wendy, I don't mean, apologize for interrupting. I did have a question though on procedure that might get to, consistent with what Attorney Bayer has said. When is an interpretation appeal timely to the Board of Appeals? At what point does one's right to appeal that interpretation expire?
Well, that's a good question. And I think the answer to that depends on how you interpret the application. Because we have many times individual members of the public have come before the Board of Appeals with no experience in administrative appeal process or law or anything like that, and they check the wrong box and they say, well, this is what I was intending to do, but I didn't quite understand the language, appeal to interpretation to allow versus variance, and this is what I meant, and I think that my application conveys that, and we've, you know, the body historically has been relatively, I would say, open in its interpretation of what qualifies, especially if someone, you know, may have checked the wrong box. So, but it's a great question because it's clearly marked variance on both, and you know, I mean, one harsh interpretation might be, well, sorry, you got it wrong, and have a nice day. But you know, you could also entertain, you know, that maybe some of the items raised in the narrative portion of the appeal maybe do speak to the elements, and maybe you want to interpret it that way as well, and allow for a hearing on that point.
Okay, assuming that in fact we accept that the applicants in these cases intended it to be an appeal based on interpretation rather than a request for variance. Is there a time limit on when that can be filed with the Board of Appeals and be timely?
Oh, it would, the deadline would be the same. So if the request for the variance was timely, then this is timely as well. I'd have to look.
Okay.
Is it 30 days? I can't remember. I'd have to go look, but how late, what was the date of the appeals versus the notice? Maybe maybe our staff representative or who's here from the inspector's office?
Well, I can give you, just based on the packet, I can tell you some of the dates. Because we have a disconnect notice in the first case in April of 2022, the first notice, second notice in April of 2023, and the appeal filed in July of 2023.
Oh, I see what you're saying. Okay. I'm pulling up I have the Shorewood code in front of me here. And I'm just looking for the section, I think it's in 535 sub 10. Here it is, Board of Appeals, Article 10, appeals. It says appeals from any administrative decision concerning literal enforcement of this chapter or any other village code provisions may be made by any person aggrieved by any officer, department, board, commission, or bureau of the village. Such appeals shall be filed with the secretary within 30 days after the date of written notice of the administrative decision or order. So that's, now so yes, that is a consideration you can make as well. Under, that's 535-56 sub B.
Thank you. Appreciate that.
I couldn't remember if it was 30 or 45, so I had to look it up.
Thank you. That's the only, those are the only questions I had.
So along that line of inquiry, Michael, for the Olive property, the 2601 East Olive, should we be considering the date of the initial disconnection notice as our kind of running time point here, which would be April 4th?
In my, I don't want to make it too arbitrary, but I mean that if you wanted to do a harsh interpretation, you would say within 30 days of April 4th, but that might be a bit, I don't know.
And this is April 4th, 2022.
Right.
So well over a year ago.
Yeah, and I would think that maybe a more appropriate date, if you will, to consider the administrative decision from which an appeal must be made, seems to me the date on which completion of a disconnect notice is required. In other words, that disconnect notice was in April of 2022, said that completion must be completed by November 1st of 2022. It would seem to me that that's sort of the last point in time, within 30 days of that completion date is the last point in time where it would be reasonable to require somebody to appeal the interpretation, because there could have been conversations back and forth with staff, working out at an appropriate location, an appropriate remedy, et cetera, et cetera. So that's why I don't want to push it too hard to the disconnect notice. Plus, we're dealing with massive notices going out at roughly the same time to a number of customers. And that would overwhelm both staff and potentially the board if everybody had to file an appeal within 30 days. So I'm kind of looking for practical application. And in this case, I mean, we've got a second notice of completion, all of which passed. And then and then it was some 20 days after the second notice completion requirement that they filed the notice. But it would seem to me that under either a very harsh reading of April 4th or a completion requirement date of November 1st of 2022, that any notice of appeal filed in July of 2023 would be untimely. And I'm prepared to make that motion to dismiss the appeal on that basis. But it's your call as to whether that should be done now or after we hear the merits, or which way you want to go.
Other board members that would like to comment on kind of the timing and as to whether these requests for review were brought in a timely manner? We were specifically talking about the Olive property. I'm looking through the agenda packet to look at our second property, which is on Beverly as well.
Yeah, and the second property, the disconnect notice went out in April of 2023 with an completion date by November 1st of 2023, which we have obviously not yet reached. The Board of Appeals application was filed in August of 2023, clearly outside of any 30-day based on the original notice, but certainly well within the time limit for doing the disconnect. And I have no idea about conversations between either applicant. Well, I take that back. With the Beverly property, I have no idea of what conversations there may have been between staff and the applicant. With the Olive property, at least based on the packet, we can, subject to testimony potentially, there was no conversation between the applicant and staff till at least April of 2023.
Other commentary from board members at this time? I'm not sure if we should proceed with.
Can I add to this? This is Deborah Sobchak. I'm the owner of Olive Street.
I'm not sure if we're
Deborah.
ready for a
Oh,
hearing
okay.
component of this
Sure.
matter yet, so.
Absolutely. Thank you.
Okay. No. I suppose I'm at a, I'm unsure of how to proceed here as to whether we are comfortable with making a determination on the basis of timeliness at this matter, or whether the board would like to proceed and hear kind of evidence and testimony from the village and the applicant before making that kind of determination.
Just procedurally, I think my suggestion would be if there's support. Oh, sorry. Can you hear me now, Mike?
Now we can.
Gotcha, okay. I just, if this helps procedurally, if there's a motion brought by someone to dismiss on procedural grounds, if it gets a second and if it passes, then obviously there's no point in taking evidence. But if it fails, you know that you're moving on to the evidence phase. So if there's, if there's no motion, then you can just move on to the evidence phase. Or if there is a motion to entertain on procedural grounds, you could just do that first.
Wendy, just for point of order, when you open the agenda item for Olive, just open that before we proceed to testimony. I will make a motion then to dismiss, because that could be, it might be a dispositive motion.
Okay. Well, then let's proceed with opening consideration of item number 6 on our agenda packet, which is a request for a variance of Village Code 225-6 and Village Code 415-18 regarding downspout disconnection requirements at residential property 2601 East Olive Street. Perhaps at this moment in time, perhaps we should clarify from the applicant as to whether they are seeking a variance or whether they are challenging the application of the conditions for disconnection at this time. As Attorney Bayer explained, we do not appear to have the authority to review a variance as the applicant has requested. However, perhaps is there one or more representatives in attendance on behalf of the property at 2601 East Olive?
Yes, I'm Rob Holly with Landworks. And I believe we would like to challenge the conditions of the, sorry, I forget the exact terminology, but amend it from a variance to a challenging the.
Okay. So my understanding is that are you disagreeing with the application of the ordinance requirements on this particular property?
Yes, that's correct.
Okay.
Okay.
Great. That being said, it's within the board's authority to hold a hearing if we so decide to review the local municipality's decision and application of the conditions for disconnection on this property if we proceed further.
Wendy, can I interject for just a moment?
Yes.
So those of you who are muted, I am muting you until you are sworn in to give testimony. So if you could just stay muted, that would be awesome. Thank you.
At this time, Madam Chairman, I'd like to move that we dismiss the request for an interpretation for the property at 2601 East Olive Street as being untimely since the appeal was placed more than 30 days from the administrative decision to, let's see, for completion of the disconnection of the relevant downspouts. That being November 1st of 2022.
All right. Do we have a second on that motion?
I'll second the motion.
Thank you, John. Would the board consider discussion amongst board members as to whether to proceed to a vote on this motion now, or whether we would like to hear evidence from the applicants and from the village?
I think we should proceed with the motion now and then proceed with evidence if the motion gets denied. Had to think back there.
That's the direction I would want to proceed as well.
All right.
Yeah, we take a vote.
Toya, can you call the motion to dismiss the request to a vote, please?
Yes. Michael Polson,
Aye.
Tara Espera,
I
John Tutenhoff,
Aye.
Wendy Smith.
Aye.
Motion carried 4-0.
With the carrying of that motion, the item number 6 on our agenda, the request for variance of Village Code 225-6 and Village Code 415-18 regarding downspout disconnection requirement at residential property 2601 East Olive Street is dismissed as the request is untimely. Moving along to item number 7. This is our request for variance of Village Code 225-6 and Village Code 415-18 regarding downspout disconnection requirement at residential property 2624 East Beverly Road. I believe the materials for this request appear further down in our packet. And as a preliminary matter, do we have a representative of our applicant for the East Beverly property on our call tonight?
Yes, it's Steve Kane. I'm the property owner. My wife, Mary
Hello,
Beth, and I.
Mr. King. Thank you
Hi.
for attending this meeting. As a preliminary matter, as you may have heard earlier, the Board of Appeals does not have authority to hear a request for variance as it relates to disconnection of downspouts. However, the board may consider an appeal of a decision by the village as an interpretation. I'm sorry, Attorney Bayer, what is this interpretation to allow?
Right, it's essentially challenging the inspector's interpretation of the code. In other words, you're saying this doesn't apply to us because the conditions aren't met or something like that.
I understand, Wendy. No, we are not seeking a full variance from the requirements. We simply disagree with the application of the ordinance to this particular property.
Okay, great. Thank you for that clarification. That being said, do we, I suppose, do we need to have a motion to hold an evidentiary hearing on this then, Attorney Bayer, or can we just proceed?
I'm
if you're comfortable with accepting that representation, we've done it. I will just note historically, the board has done it in the past where people may have checked the wrong box or not quite understood the categories. So I don't, unless procedurally you want it for the record, I don't think it's necessary.
Okay. Unless there are objections from the board, we'll proceed to an evidentiary hearing on this matter concerning the East Beverly property. To begin, perhaps Inspector Burris, are you available to provide a statement on behalf of the village concerning this matter?
Yes.
Inspector Burris, can you raise your right hand? Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
So in our packet, both I and Leanne Butchlick, Director of Public Works, both provided memos with respect to the program and inspections that were conducted. And so I won't run through them verbatim as it's a lot of information. But I'll touch on this initially is that, so on February 1st, 2021, the village board adopted the combined sewer service area disconnection, downspout disconnection program, and that this program addresses approximately 1,946 residential properties within the combined sewer area. So in this case, again, I would say that this notice went out April of this year, and that the applicant was timely in their request for, say, the appeal of our interpretation. So this property was initially reviewed by the village engineer. So we subcontract with Strand Engineer. They're the engineers that conducted the survey of the entire area and determined which downspouts needed to be disconnected and those that may remain connected due to, say, impervious surface areas being in place, walkways, driveways, things of that nature. And so when the village is contacted, the first point of contact is with the DPW. That if there is, again, someone disagrees with that interpretation, it goes to the DPW and they either affirm or again, review the site conditions, and in some cases have determined that that the engineer may have, misjudged the conditions and does provide that interpretation internally. Additionally, our department, the Planning and Development Department, plumbing inspectors, either myself or our other inspector, Tim Kep, will go out and review the site to determine if there is sufficient area. So again, with there having been, say, we have like 1,900 of these properties, the conditions of the lots within the village are generally fairly uniform. And so it is easy to determine in our estimation whether or not that engineer's decision was correct or not. And again, in this case, the downspouts that have been required to be disconnected, we affirm the engineer's initial determination, both our department and the DPW, and believe that the request should be denied.
Could I ask, Justin,
I'm sorry,
we are
Steve.
only,
Steve,
Sorry.
we'll get to you in a moment, I
Okay.
promise. Thank you.
Thank you, Toya. For members of the board, are there questions for Inspector Burris at this time?
I have a question. Mr. Burris, did you personally inspect this property?
I have not personally inspected this property, no.
And so Inspector Burris, we have a report that has a number of photographs. This is beginning on page 32 of our packet. And a number of these downspouts are ordered to be disconnected, and others are classified as being exempt. And perhaps this is a better question for our applicant, but is it your understanding that is there a particular downspout that is being appealed in this matter?
Yes, so there are 1, 2, 3, 4, 5 downspouts identified in the report. And I believe it is that there are 2 that are, well, one is already disconnected adjacent to a rain barrel. So there are only 2 that are required to be disconnected and are non-exempt. And from my understanding is that these are both on the front of the house. And again, the understanding is that you have area within the front yard where the downspout can be effectively discharged 5 feet from the foundation, and there's area there that water may be discharged to.
Okay. Further questions for Inspector Burris? Okay, hearing none. Our representative for the applicant, if you would like to make a statement about the nature of your request and the conditions of your property, that would certainly be helpful for the board. Toya, can you please swear in our applicant?
Mr. Keen, am I pronouncing your last name correctly? Kane?
Oh, you're on mute.
Yes,
Sorry, it's Kane, but that's close enough.
Kane, okay. Mr. Kane, do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
I first off, thank you everybody for your time and attention. We've been directed to divert several downspouts away from the village storms sewer inlets on our property, including the downspout on the southwest corner of our house, which is the front, one of the front downspouts in our house, next to our driveway. We asked that this one downspout could remain flowing to the village inlet for safety reasons. The slope of the yard in the entire area near this downspout would shed water into the adjacent driveway and sidewalks, with a very small area of yard sloping very steeply into our driveway, as well as our neighbor's driveway. We have a shared driveway with the property next to ours. So to the extent water is flowing off of our property, it flows into driveway space owned by our neighbor, and also flows into unfortunately, their basement. They've got some significant basement issues on that side of the house due to how things are set up. Our concern is that, water flowing across the pavement will freeze under certain conditions and create slipping hazards. The driveway, as I indicated, is shared with the neighbors as well, so the safety concern would flow over to our neighbors. The area is surrounded by walks and driveways, so there's not a safe place for the water to go other than the village inlet. If you look at photos of this particular corner, again, there's significant slope from where the inlet and downspout are located, and then it's about 2 to 3 feet before it it hits our driveway. So there really is no space in this particular location and significant slope for where the water flows from that location.
Mr. Kane, do you mind if I clarify for the purposes of the board members looking at our packet? Do you have the packet on hand by chance?
I do
Mr.
not
Kane?
have the packet in
Okay.
front of me.
I believe the downspout that Mr. Kane is referring to is the third photograph on page 33, at the top of page 33. I believe this is to the left-hand side of the front door if you're looking at the front door. Is that correct?
Yes,
Okay.
correct.
And that's the only downspout that you're asking for reconsideration.
That is the only downspout we're seeking reconsideration for.
Okay, thank you.
We fully understand the goal is to reduce the amount of water flowing into the village storm sewer system in accordance with the mandate from MMSD. The majority of our other downspouts, in fact, have already been diverted. We have current work going on at our house and have already made arrangements for all the other downspouts to flow away from the storm sewers that they originally went into, including one where we were granted a variance. So in some respects, what we're almost asking to do is take it from one corner of the house where we got a variance and we're allowed to allow water to continue to flow into the storm sewer. And we have instead run a downspout further into our yard to divert that water and want to convert the one that's close to our driveway and where we have a safety concern, in order to allow that one to remain intact. We believe under these circumstances, the safety concerns outweigh the burden of water in the storm sewer from this one single downspout where we're asking for a different application. I do believe a number of the factors that Attorney Beyer indicated could allow for reapplication of the ordinance under these circumstances are applicable here. We don't believe there is enough space. There is not 5 feet from the downspout before you're running into concrete. So I believe the second factor is satisfied. On the third factor, that there is sufficient pervious surface available, we do not believe that element is satisfied because, again, there is concrete and driveway within about 3 feet from where that downspout is located. And also, I believe the fourth factor was, that it is not a level piece of land and or has a steep incline, which likewise accurately describes this southwest corner downspout where we're seeking a different application. We believe this is reasonable. I think, frankly, the amount of water that'll be diverted from our house, since we have taken one where we had a variance granted and will not be using the storm sewer system at that location. We're simply asking to move it to this other corner of the house, would be a reasonable way to address the situation and not result in any additional water, candidly, flowing into the storm system than the order we originally received.
May I speak to a few of the elements discussed?
Would you mind holding just, do members of the board first have questions for Mr. Kane before we provide Inspector Burris with some opportunity to rebut?
I have some questions, if I may. I'm looking at the survey as well as the photograph of that particular corner, Mr. Kane. So I just want to make sure I understand it. is it from the survey, it looks like you have a driveway with, for lack of a better term, 2 strips of concrete and some sort of median that may or may not be grass.
There is no median between the driveway spaces. It is all concrete
Okay,
all the
just,
way across.
yeah, the survey made it look like there might be sections. So, okay, it's all concrete. You have a concrete driveway, and adjacent to you is based on the survey anyway, your neighbor's concrete driveway. They're immediately adjacent, and you essentially call it a double width driveway, if you will, completely covering the space between the 2 houses. Is that
Yes.
correct?
Correct.
Okay, and based on the survey again, it looks like, and you've described it as a slope, approximately 3 feet between the edge of your driveway and the side of your house. Is that correct?
Correct.
And then based on the picture, it looks to me like the downspout is set in from the corner of the house somewhere between 1 and 2 feet from the corner. Is that correct?
Yeah, it's hard to tell from the photo because I think the downspout was removed in this photo, so you cannot see where it is typically located. But it is located, if you look at the corner, it's located, probably 3 inches to the right of the corner seam on the house.
So,
Right at the front.
Yeah, so if I'm looking, but it
we-
looks like, I'm sorry, I don't mean to interrupt.
If I'm referring to the right photo, my
Yeah,
apologies. Sorry.
Let's see. I'm looking at one, yeah, they're hard. The one I'm looking at, let's see, you could see the corner of the house, you could see the sewer insert, the downspout goes into that insert, and then it kind of slopes down with a bunch, for lack of a better term, it may look better out in person, weeds kind of on a little bit of the slope, if I'm looking at the right one.
Correct.
Yeah, so it's, and if I look at that one, it looks like there's a foot or more to the sewer insert that the downspout would be connected to. Is that correct?
Could you rephrase the question? I'm not sure I understood it.
Yeah, I'm just trying to get the position of the downspout from the corner to where the downspout is coming down. And you said a little while ago, you thought it was the downspout was disconnected in the picture, and it doesn't look like that to me. So that's why I want to make sure I'm looking at the right picture.
I think my wife might have sent me the wrong picture that was submitted. Okay, that is helpful. And yes, if you look at the top photo, that is reflective of the downspout as it existed and as it's been reassembled, actually, following some housework we've done.
Okay, thank you. I'm just
So
trying to.
if you can see the weeds, and we do have to do some weeding, the weeds just to the west of it, it's a couple of feet and sloping downward, and then immediately hits the driveway right at the bottom of that picture.
Okay, thank you. That clarifies it for me. And then a final series, I hope just 1 or 2 questions. As I understand, and again, I'm looking at the survey, the house is set back some 36 feet from the front. Well, I can't, more than 36 feet from the sidewalk. And you're roughly, it says the corner of the house is roughly 12 feet or more from that front porch. So you've got a pretty good sized section of lawn between call it the corner of the house to your front walkway and front porch. Is that correct?
Yeah, there is some lawn in front of that downspout, but it slopes significantly to the west.
So facing the house, it slopes down
Slopes
towards
to the
driveway?
west and towards the driveway.
Okay,
So water that would be drained if we ran a downspout into the lawn at that location will flow to the west and onto the double driveway.
and what's the approximate elevation of the front lawn to the driveway? Does the slope start, where does just guessing from my own lawn, part of the lawn is level and then it starts sloping to the driveway. What, can you describe the approximate height and where the slope is on that portion of the lawn?
I think it probably the slope is probably 3 feet or so from the from grade down to the driveway. And it begins probably somewhere in the middle of the yard.
Okay, thank you. Those are all the questions I have at this time.
Any additional questions for Mr. Kane from board members?
Stephen, you mentioned that there's this is the only one that you're concerned with, but the one to the north of the house, it appears also is what are the plans going on with that one?
I think the one to the north of the house is being diverted already. We've got that going into the yard and have it disconnected following some work that we performed.
That one's already been disconnected, huh?
Yes.
Because that's also close to the neighbors to the north driveway, correct?
Yes. Or neighbors to the east, are you thinking of?
Yes, to the east. Sorry.
Yeah, it is closer there, but you know, we were, I think, ran it back into the backyard. Like that one may remain, but there's another one in the back, I think, where it was granted and we were able to run that one away. I may candidly need some help from Justin on this because he's got the Strand reports, but one of the locations where we were granted a variance to continue to stay connected into the stormwater system has been diverted.
So for our purposes, the only downspout at issue is the one on the
Southwest corner.
southwest corner.
Yes.
Okay.
And one of the other downspouts that Strand indicated could remain connected has been disconnected. Because we were able to, I do not believe it was the one on the east side of the house shown here, but it is one of the other locations it's been taken care of.
Additional questions for Mr. Kane?
Might be that one.
Mr. Kane, in addition to using the driveway for cars, do you use the driveway for walking from the sidewalk to the rear of the house, or is it primarily used for vehicles?
Yeah, we walk on it all the time. Neighbors have many children. it's our primary path to get to the front of the house.
Okay, thank you. Additional questions for Mr. Kane before I believe we'll provide Inspector Burris an opportunity to provide additional information?
It is the other front downspout. Just to clarify for Inspector Burris, it is the other front downspout on the east side of the property that we have diverted.
Where did you
Okay.
divert it to?
We diverted that into the yard, the front yard, because it is flat on that side. And water doesn't flow from that location into our east neighbor's driveway.
So I think what John was getting at earlier is what did you do with the northwest downspout? The one that is also adjacent to the driveway?
It would be the southwest or southeast. We're talking
No.
about that.
We're currently talking about the southwest corner. Is the northwest corner also a downspout location that is adjacent to the driveway?
There were only two that were non-exempt. All the other three are exempt.
Okay, so the other downspout adjacent to the driveway is not an issue here.
Yeah.
Okay, got it. Okay, Inspector Burris, did you want to provide some additional information?
Yes, thank you. So just again, to touch on the disconnection criteria. One, the roof drain is external, no question there. Sufficient space is available to locate the discharge point at least 5 feet away from the basement or foundation walls and property lines. So it is not specifically that it has to be 5 feet away from any concrete or impervious surface, but from foundation walls. And again, in many cases, what we've seen is that, we don't require people to use, say, aluminum downspout material. Obviously, they make flexible connectors that make it very easy to direct water in a way that, it doesn't have to run straight out from that corner, right? It could be kind of routed through bushes on the front of the house and more towards the center point of the front yard. With respect to the slope, the discharge location slopes away from the structure, but not so steep that the discharge would cause erosion. So not that we don't have interior lots with steep slopes, but again, we're thinking about erosion. Obviously, we have a number of houses. All of the houses on Lake Bluff on the lakeside are in the combined storm and sewer area. And so to the point of causing erosion, we don't want people to disconnect downspouts and just dump it on the back of the bluff, where it would lead to a heavy deluge during rain events in a concentrated area, leading to erosion. And number 5, so discharge water will not create ice on pedestrian walkways or a nuisance for adjoining properties. So while I don't think that this request is unreasonable at all, especially knowing that, say, there's we're at this point learning this evening that there's a trade-off for downspouts. Again, I don't think it's an unreasonable request. With that said, the idea of creating an icy situation. So I will say that 85% of the time, what we're dealing with here is the gutters and downspouts are intended to direct rainwater, right? So generally, when they're doing their job, and what we're trying to do is keep stormwater out of the combined sanitary sewer, is during rain events. So everything's wet anyways, right? So we're not really concerned about, is it adjacent to a driveway during a rain event? There are times in say early spring and maybe early winter when we had snowfalls and ice melts and things like that. And so snow is melting. But generally, if snow is melting and freezing on these surfaces, so again, driveways and things like that, you generally have you got snow on your lawn, on your roof. You have snow in other areas that is melting and freezing. It isn't as though a gutter, a downspout that is discharged near a walkway is going to increase the amount of, say, ice on a surface. All of us deal with it and having to, salt our sidewalks and things because downspout or not, we end up with icy surfaces. I've only encountered one time in Shorewood when someone had a roof melt cable on their in their gutters, and so they were melting snow and ice on the roof when it would otherwise not be melting, and that created a significantly icy situation on the sidewalks. But again, I always kind of take umbrage with the, create an icy situation, because if snow and ice are melting, given the time of year, based on the sun, and then, cloud cover or nightfall comes and it gets icy, it is my opinion that those areas become icy whether or not that, there's a nearby downspout.
Yeah. Yeah, I would just communicate there are already some pretty significant ice conditions located on the driveway. Since, as you can tell from the photos, there's really very little space on our side for snow and or water to flow, and none on our neighbor's side next to their foundation. I'm just concerned that additional water will exacerbate the problem. And we believe, with help and support from our contractors, including the gutter contractor who's already done the disconnects, a change out of a 1-for-1 at this location is reasonable and appropriate as a way to apply the ordinance in accordance with the MMSD's requirements in a way that works for what we've experienced at the property living there.
And perhaps I can just get clarification from Inspector Burris. Do you believe that disconnection of this particular downspout will create some ice on a pedestrian walkway?
I believe that this downspout could be disconnected and directed in a way that would not create an icy condition on a walkway.
What about in the driveway?
I'll maintain that I believe that the downspout could be directed in a way that it would be imperceptible. You'd never know.
Okay.
And then I would just redirect the board back that Inspector Barris has not been to the property and inspected this location.
All right, additional questions or commentary for Inspector Burris or Mr. Kane? Okay, Mr. Kane, any final thoughts before we close the testimony portion of this meeting and go into deliberation?
No additional comments. I appreciate everyone's time. Inspector Burris, I appreciate your time. 1,900 downspout locations and properties is a lot. And, my view is just this one change out of like 1-for-1 is a reasonable accommodation, and I think will allow the property to be managed in accordance with MMSD's requirements, but in a way that does not contribute any additional water into the sewer system. So I do just appreciate everyone's time and patience.
Well, thank you. All right, at this time, we will close testimony portion of this matter and we'll open it up for discussion amongst board members. Attorney Bayer can correct me if I'm incorrect here, but our stated standard of review for this appeal is looking at the village's determination for substantial evidence to support the decision or the determination to disconnect this particular downspout. And what we're looking for is a rational, non-arbitrary basis for the decision. With that being said,
That's exactly,
okay, great.
that's correct.
Thank you. With
Yep,
that
that's
being
exactly
said,
right.
do we have comments from the board as to whether we believe that the village did rely on substantial evidence to support their decision here?
Well, I believe that the village worked well in accordance and the photos and everything else provided to make a good decision. If that's what we're debating.
I'll jump in with my 2 cents. I empathize with the applicants and their dilemma, because it looks very similar to some downspouts that I was facing. And I understand their concerns. And if I were to be making a de novo decision based on everything I've seen so far, I might well want to interpret his situation as permitting or as not requiring disconnection. I guess that's the way I have to phrase it. But unfortunately, that's not my role here to make a decision, because I think he's making some important arguments, and the situation is a very, very close case, and that I think a decision to not require disconnection would, if the village had made it, would have been a reasonable one. But by that same token, then their decision to require disconnection, since it's a close case, is not an arbitrary decision, and it's not an unreasonable decision. And based on the description of the property, the amount of space in the front lawn, the amount of space to the driveway, the impact of rain water versus snow melt, and the various climatic conditions that Mr. Burris was referring to, all of which lead to at least a reasonable basis, in my view, for the staff and the village's decision to require disconnection. So based on the limitations that the law is placing on us, and that we can only reverse a village administrative decision if it is arbitrary and call it irrational or unreasonable, that I can't make that determination. It seems to me there is substantial evidence within the meaning of the law, as stated by Attorney Bayer, that we should, in my view, we should affirm the village staff interpretation and application of the ordinance. That's my 2 cents.
Yeah, my line of thought is pretty similar to Mike's. I wish we were granting a variance in this case, because I think there is ample evidence that would support granting one here, but that's not the question we're being asked tonight, unfortunately. I don't have anything to add other than that.
Yeah, I tend to agree as well. If our proper standard of review here is to afford the village and its contracted engineer deference in its decision-making, seeing as that particular department has expertise beyond the members of this board, it seems as though, although the solution may not be ideal for the applicant of having kind of a discharge hose into the yard as opposed to kind of a straight discharge, it does appear to me that the decision made by the village was not irrational and not arbitrary, so I would be inclined to support their decision. That being said, if we are prepared to move on a motion,
I think Justin has his hand up.
oh, I'm sorry. I guess, Justin, do you have one final comment?
Yes, if I may, and I apologize because, again, I understand the memos were a bit lengthy, but I did want to just, again, with respect to the disconnection criteria, point A and point B. So, and this goes to the applicant as well, is that point B states that if after disconnection and implementation of all practical on-site stormwater management techniques, if roof drainage has caused property damage or unsafe conditions, then reconnection to the combined sewer is allowed. So I understand we didn't hear the first applicant's request and things, but that is an important piece of the program that we work to implement these things, and then if there's an issue, we come back to it. So it isn't necessarily a one and done, never back.
Thank you. Good point. I forgot. I meant to mention that myself.
Thank you.
Thank you, Inspector Burris. All right, if we are ready to proceed to a motion, does a member of the board have a motion to dispose of this matter? And I'd have to think about what the motion is to be, but if a member of the board would like to propose a motion to dispose of this matter, I encourage you to speak up now.
It would be either to overturn or sustain the decision of the.
Yeah, right. I'll make a first shot at phrasing a motion. I move that we sustain the village application of the stormwater disconnect program to the property at 2624 East Beverly Road, such that that may be enough. I was just going to clarify, do we want to go on? Because we're not talking about all 5 downspouts, just the one that's at issue here. I'm not sure if it's necessary to specify the downspout at the southwest corner of the property or whatever. That's where I stopped.
I don't think so.
Yeah.
Is there a second?
I second.
Wendy,
you,
may I
Chair.
read back the motion just to make sure I captured it correctly?
Yes.
Okay. Michael Polson moved to sustain the village application of the stormwater disconnect program to the property located at 2624 East Beverly Road.
I couldn't think of the ordinance number, so I threw in the
Okay,
generic
all right, I'm
description.
sorry. Then I will go ahead and include Village Code 2025-6 and Village Code 415-18. Correct? Okay, thank you.
Okay. Toya, can you call this motion to a vote?
Yes, sorry. Wendy Polson?
Oops.
Is that Michael
Michael.
Paulson?
Oh my gosh. Okay. Michael Polson?
Aye.
Wendy Smith,
I vote to sustain. Yes, aye.
John Tudenhoff,
Aye.
and Cara Espera.
Aye.
Motion carried 4-0.
Okay, with that being said, this matter, the request for appeal, the decision of the village has been sustained with the important note that Inspector Burris raised earlier of the availability of reconnection if the criteria for reconnection exists. And I believe Inspector Burris said that was property damage or unsafe conditions. That concludes the requests on our meeting agenda. Unless I hear objection from the board, it appears that we can adjourn this meeting. Hearing no objection, this meeting is adjourned. Have a good
Thank you
evening.
much.
6:46 p.m. Thank you, everyone. Have a great
Justin.
night.
Have a good night.
Would be great if you could send somebody out maybe to take a look at it. I think if you take a look,